My name is Jim Toot, and I'm an Associate Professor of Political Science here at Central Virginia Community College. The Courts, Part 1, the U.S. Legal System. The U.S. legal system draws upon its common law tradition, which originated from England. Common law is judge-made law made from decisions based on prevailing customs or precedent. It operates not only on the concept of precedent, but also stare decisis, which is Latin for to stand on decided cases. The Anglo-American legal tradition has 5 sources of law. In addition to common law, or judge-made law, we have international law, constitutions, including U.S. and states, statutes, or legislated law, and administrative law, or regulatory law. At this point in the lecture, I would like you to watch Scott Wishart in his lecture introducing you to the origins of the Anglo-American tradition. After you're done with that lecture, please return to this video. In the U.S. legal system, we have civil cases. In civil cases, plaintiffs, people, or organizations initiate lawsuits against defendants, and courts resolve disputes by deciding or mediating between the two sides. Civil cases generally involve money, contracts, property, personal injury, divorce, or child custody. "I'll sue you" is a threat to instigate a civil action. The vast majority of civil cases, some 17 million annually, are filed in state courts compared to around 400,000 in federal courts. And civil cases are decided based upon the preponderance of evidence. In other words, towards which side, the plaintiff or the defendant, does the evidence suggest the correct outcome should be, as opposed to in a criminal case where we require guilt beyond a reasonable doubt. State and federal laws establish the type of civil cases their courts can hear. For example, because there is no federal divorce law, all divorce cases are heard in state courts. Because Social Security is a federal program, all civil disputes involving it are heard in federal courts. Because of their cost and often lengthy delays until they are heard in court, only about 1.3% of civil suits filed go to trial. Most civil cases are resolved by other means, such as settlements, plea deals, mediation, or arbitration. Criminal cases are initiated by the government. They run the gamut from misdemeanors such as trespassing and disorderly conduct to felonies such as armed robbery, rape, and murder. Unlike civil cases, criminal cases can result in the loss of liberty, a jail sentence. Around 7 million people in the United States are either in prison, on probation, or on parole for crimes committed. Most criminal laws are passed by states, and the vast majority of criminal cases originate in state courts. Roughly 21 million criminal cases annually, compared to about 76,000 in federal courts. Around 27% of the criminal cases heard in federal courts involve alleged violations of federal drug laws. Often requiring mandatory sentences without parole, these federal laws are much tougher than state laws, so it makes an enormous difference whether a drug offense case is tried in federal or state court. Only about 4% of criminal cases are decided by trial. Prosecutors drop or do not continue with charges on another 25%. Most of the rest are resolved by guilty pleas without going to trial. Even for murder or manslaughter, a majority of defendants plead guilty. This often entails a plea bargain in which defendants plead guilty in exchange for a reduced charge. The judge must approve the plea bargain. Except for affluent defendants with high-powered and well-paid attorneys, people involved in criminal cases have an incentive to plea bargain. Defendants who insist on going to trial face sentences that can be far longer than those received by defendants who pled guilty and cooperate with the government. For lawyers and judges, plea bargains save both time and trial costs and also lighten their workloads. Because so many plead guilty, 47 million Americans have criminal records. The first sentence of Article 3 of the U.S. Constitution created the U.S. Supreme Court, a major innovation. The Articles of Confederation made no provision for a federal judiciary, and only for courts created and controlled by the states. Article 3 also gives Congress the authority to create lower courts. After the Constitution was ratified in 1789, Congress quickly did so through the Judiciary Act of 1789. There are 94 federal district courts, staffed by 667 permanent and several temporary judges. Every state has at least one district with a district court in it responsible for hearing cases that arise within that geographic area. In the chart here, you see the divisions in the federal judicial districts of Virginia with both the eastern and western districts. In the eastern district, there are courthouses in Alexandria, Newport News, Norfolk, and Richmond. And in the western district, in Lynchburg, Harrisonburg, Charlottesville, Danville, Roanoke, Abingdon, and Big Stone Gap. Above the district courts are the federal courts of appeal. They decide whether or not district courts have made an error in conducting a trial. Judges on appeal courts base their ruling on written and oral legal arguments presented by lawyers for each side. There are no witnesses, no testimony, and no jury. Appellate courts answer questions of law rather than questions of fact. There are currently 13 courts of appeal, 12 of them based on geographic districts called circuits. There are 11 numbered circuits, each of which has jurisdiction over several states. No state straddles more than one circuit. Again, you can see the geographic boundaries of the 11 federal circuits. There is a 12th circuit for the District of Columbia, known as the D.C. Circuit. The 13th Circuit is the Court of Appeals for the Federal Circuit, which hears appeals from U.S. Courts of Federal Claims, International Trade, the Patent and Trademark Office, and others. There are approximately 179 judges on the Courts of Appeals. A case in district court is usually presided over by one judge, whereas appeals before a court of appeals is typically heard by a panel of 3 judges. A majority vote of the panel is necessary to overturn a lower court ruling. The Court of Appeals issues a written ruling explaining its decision. Every litigant in federal court has the right to appeal an unfavorable ruling from the district court. However, because it is so expensive to appeal, only about 17% of the eligible litigants do so. The Supreme Court, the nation's highest tribunal, hears cases arising under the Constitution or the laws of the United States. The Constitution gives Congress the authority to set the number of Supreme Court justices, and it has changed the number several times. It started with 5 justices, it now has 9. The Constitution does not stipulate any specific qualification, nor even a minimum age or legal training for Supreme Court justices and other federal judges. Of the over 100 individuals who have served on the Supreme Court, all except for 4 women and 2 African American males have been white men. Article 3 and the 11th Amendment of the Constitution require that the Supreme Court be the first court to hear certain types of cases. This original jurisdiction is limited to cases between the United States and one of the states, between 2 or more states, involving ambassadors or other ministers, or brought by one state against the citizens of another state or against a foreign country. Only about 1% of the Supreme Court cases fall under its original jurisdiction. The rest reach it as appeals from civil and criminal cases that have been decided by lower federal and by state courts. As the highest appellate court in the nation, the Supreme Court is the ultimate arbiter in many areas of the law. If the case involves a federal question, an appeal can be made from the state's appellate court of last resort to the U.S. Supreme Court. A federal question exists if the law is alleged to violate federal law, an act of Congress, a treaty ratified by the U.S. Senate, or the U.S. Constitution, or because something that state officials do is claimed to violate the Constitution or federal law. Grounds for appeal include evidence gathered from an unreasonable search and seizure, a coerced confession, and infringement of a constitutional right to a fair trial. With rare exceptions, the Supreme Court has absolute control over the appeals it chooses to hear. Of the roughly 8,000 cases appealed to the court every year, the justices typically agree to review a few hundred. The justices normally decide around 70 of these, with comprehensive written opinions during the court's annual term from October through late June to early July. The court occasionally issues per curiam decisions or brief unsigned opinions, usually for cases it decides without an oral argument. The justices do not have to give any reason for accepting or rejecting a case. Even after deciding to hear a case, they can change their minds and dig it or dismiss as improvidently granted. In other words, they say that they won't decide the case after all, again without giving any reason. Most cases reach the court by way of a writ of certiorari. Certiorari is Latin for to make more certain. Litigants who receive an adverse ruling in the Federal Appeals Court or, in cases involving a federal question, from a state's highest appellate court, can submit a petition for a writ of certiorari to the Supreme Court asking it to review the case. It takes 4 of the 9 justices to grant cert. This is called the Rule of 4. If the Supreme Court does not grant cert, the lower court ruling is left standing. This does not mean that they agree with that ruling, only that the court has chosen not to review it. When the Supreme Court grants cert, it is usually because 4 or more of the justices believe that the case represents an important issue, such as an unresolved constitutional or statutory question on which they are interested in ruling. Sometimes disputes between different courts need to be resolved, or Congress and the lower courts need the court's guidance on the Constitution. However, it is not unknown for justices to avoid granting cert to important cases because they do not want to rule on them. The case for cert is strengthened if it is backed by the Solicitor General, the presidential appointee in the Justice Department, responsible for presenting the position of the U.S. government to the courts. The Solicitor General screens cases before most agencies of the federal government can appeal them to court. Consequently, more than half of the Supreme Court's workload comes from cases under the Solicitor General. The justices pay special attention to the recommendations of the Solicitor General. When cert is granted, the lawyers for each side file a brief making their arguments. Others with a stake in the outcome of the case may, with the permission of the court, each file an amicus curiae brief on behalf of one or the other parties to the case. These Friends of the Court briefs expose the justices to additional arguments and enable them, should they be so inclined, to gauge intergroup attention to a case and the amount of support from different sides. After reviewing the briefs, the justices hear oral arguments, usually limited to an hour split equally between the sides. The justices often interrupt the attorneys with questions, probe arguments made in the briefs, and raise new issues. They may indicate their thinking about the case and possible decision. The arguments can be used by the justices to reach the legal and policy decisions they prefer. Each justice selects a few law clerks, usually 4, to assist in researching cases, deciding which ones to accept and drafting opinions. These clerks are usually honors graduates from the most prestigious law schools. A clerkship betokens a promising future in the legal profession. Because the clerk's work is confidential and rarely revealed, the extent of justices' reliance on their clerks is uncertain. One former clerk writing about the court charged that the justices granted great and excessive power to immature, ideologically driven clerks who in turn used that power to manipulate their bosses. Most justices are so self-confident and versed in the law that it is hard to imagine them being led to make decisions against their will. Sometime after oral arguments, the justices meet in a conference and vote in order of seniority, starting with the Chief Justice on how the case should be decided. The Supreme Court decides the case by majority rule. At least 5 of the 9 justices need to agree for a majority opinion. They do not, however, have to agree on the reasons for their decision. It is possible for a majority to be composed of justices who agree on their rationale for the decision, plus justices who join in the decision, but for other reasons, and thus write a joint or individual concurring opinion. Justices who disagree with the majority opinion almost always write a dissenting opinion or join in a colleague's dissenting opinion, explaining why they think the majority was wrong. On rare occasions, when a justice wants to make a dramatic statement arguing that the majority is profoundly wrong, she or he will read this written dissent aloud. The intimacy of the Supreme Court is best captured by the conference room where the 9 justices meet to vote on which cases to hear, to discuss opinions, and to decide cases. The junior member of the court is responsible for opening and closing the doors. Bargaining and compromise sometimes ensue in an effort to create a majority coalition. The Chief Justice, if voting with the majority, determines who will write the opinion. Thus, many of the court's most important decisions are penned by the Chief Justice. If the Chief Justice is not in the majority, the justice in the majority who has served on the court the longest takes the assignment. In summary, most criminal cases are decided by plea bargains. A few trials attract abundant coverage in the news and entertainment media, which depict them unrealistically. The federal court system consists of 94 district courts, with at least one in each state, and 13 appeals courts, each one with jurisdiction over several states. At the top of the judicial system is the Supreme Court, and the Supreme Court's decisions entails briefs, oral arguments, conferences, clerks, and opinions.